Good afternoon, everyone. Welcome to the Neighborhood Christian Legal Clinic's Facebook Live presentation. Today, we're going to be talking about tenant rights for domestic violence survivors. And this is one of our preventative legal education workshops. To start out, let me tell you a little bit about myself and introduce myself to you. First of all, Indianapolis is my community. You are our neighbors, and we want to work with you to make sure that you're being represented, and as well as making sure that people in the community know their rights so that they can protect yourself from any legal entanglements that might occur. And that is the purpose of this education program. And as part of my community, this is very important to me because I think it makes it a better community. I have been an attorney for 21 years in the Indianapolis community, and my experience does include litigation, legal issues concerning domestic violence, government law, and eviction law. Once again, this is a preventative legal education workshop. What that means is that this presentation is to give you some basic information to protect your rights. This is not an attorney-client relationship that is being created, which means I cannot answer specific case questions. However, if you do need additional legal assistance or want to learn more about our services, please visit us at www.nclegalclinic.org, and you can see what type of services that we do have. Today's presentation, once again, is the rights of domestic violence victims, as it is the rights to housing and as a tenant. And specifically, we're going to be talking about individuals that have orders for protection or no contact orders. The 3 points that you will be learning today is, first of all, what is an order for protection? You might also have heard it called a protective order or a no contact, and what is a no contact order. And then we'll talk about who is protected and what are your rights. First of all, what is a protective order or no contact order? Those two legal creatures are a bit different. We'll first go over the order of protection, which is issued by a civil court. A civil court basically is any court that's not a criminal court. Any individual may request a protective order by petitioning a civil court, and pursuant to Indiana Code 342659, a court may order many different forms of relief from a protective order. Some of the forms include ordering a respondent from enjoining them from committing or attempting to commit acts of domestic or family violence against you, contacting you directly or indirectly, harassing, ordering them to stay away from a school, residence, and a huge one, which is one of the newer provisions in the law in the last few years, they could actually order that the respondent be removed from the residence that you live in. And that doesn't matter who owns the residence. So you don't have to be on the lease as a tenant, or even the homeowner beyond the tenant rights. So the court can order the perpetrator out of the home. Additional forms of relief would also include possession or use of an automobile, once again, the residence, and other personal effects that you may need. They can order the help of getting those personal belongings through a police officer. I recommend highly that you use that if you need to. I've had cases where respondents have tried to use those opportunities to hurt people in those contacts, including I had a case where the respondent in a protective order was trying to utilize a contact and get the victim to obtain her stuff in a plot to kill her. And it was a pretty serious matter. So take these things seriously, and that's why these rights are here to protect you. So I highly recommend as a point to utilize and ask the court to ask a law enforcement officer to help with those types of matters. A self-protective order that we're going to be talking about are no contact orders. They are a different creature. Like I said, you cannot petition it. Usually it's done by a prosecutor, and a criminal court will order it, or someone like Department of Child Services, CPS attorney may ask a juvenile court to order it when there's a child who's a ward of the state living with a foster family. No contact orders are a lot more narrow, basically ask usually people to refrain from contact. In a criminal court, it's usually part of a pretrial release, executed sentence, or probation. Also, as a victim, if you're the subject of the no contact order, I would say that your input is considered but not necessary. A criminal court can order a no contact order against the victim's wishes. And as a prosecutor handling domestic violence cases, I did see that happen quite often. So because they are totally two different creatures, orders for protection and no contact orders are not interchangeable. They have different forms of relief. Once again, who's in control of the order, who's actually the petitioner asking for the relief is different. So there's several different things that make them different. And because of that, there's a lot of law saying that you can have both. It's not one or the other. So if you ever are seeking a protective order, you may ask for one in addition to a no contact order, because you could get different relief. You have more say in what you want in the order by asking the court. Of course, the judge will make the ultimate determination. And the court cannot delay granting a relief because of the existence of a pending action between you and the petitioner or respondent. So you can have more than one protective order. Now, if you do ask for some additional relief through a new protective order petition, and the court grants it, they will, and there is another case with you and the respondent, or if you and the respondent have a child in common and there's a pending litigation concerning that, the court will then transfer the matter to the court where that case is pending. Often that happens in a family law case, such as a divorce. So what might happen is you have an emergency situation, you petition the court for an ex parte protective order to get immediate relief, they grant it, and then it is sent to your divorce court. There's a lot of information out there, and I encourage you to use it. Right here at in.gov court self-service protective orders, there is a lot of great information to use. I recommend you go there. It talks about rights. It talks about advocacy, advocate agencies in different counties. All these things are very useful tools. You can see there's a lot of wonderful information there. So I highly recommend that you utilize these services and look around. And once again, this does not take the place of an attorney. So if you are seeking one, I do recommend getting an attorney for services. The next part of the presentation, we're going to talk about exactly who is protected by these rights as a tenant. And these are rights that are created through statutory protections, and certain victims or alleged victims of certain crimes are the ones that could be protected. First, these laws for tenants means it's any individual who's renting a structure that's a dwelling. It does not matter what type of structure. It could be an apartment, boarding house, or rooming house, manufactured home, including where the home is located on the space you occupy, single or two family homes. So it does not have to be an apartment building. It could be anywhere where you have a landlord renting places to you. You have to be a victim of certain types of offenses to get these tenant protections that we're going to be talking about. First set is crimes involving domestic or family violence. There's several different crimes that could be under this category, but one common feature, it has to be a family or household member that attempts to commit or commits this crime. They include homicide, battery, kidnapping, sex offenses, robbery, arson, mischief, burglary, voyeurism, stalking, and it could even be some animal cruelty and other offenses. So there's a slew of offenses. I'm going to caution on stalking, particularly if you get a case such as stalking, you're definitely going to want to talk to an attorney, because there's very specific statutory requirements on what is considered stalking. Now, there are two other offenses that you can be a victim of to be protected by these for as a tenant who is a victim of violence, sex offense, or stalking. Now, this does not have to be a household member or a family member. And the perpetrator, the respondent, has to be convicted or has to be determined to have committed it by a civil protection order for these rights to be invoked. So that means if you have a no contact order from a criminal court, there actually has to be a conviction to obtain these tenant rights as a victim of domestic violence or family violence or any other type of violence that's mentioned. Now, in a civil protection order, there does not have to be a conviction. What you do have to have is the civil court make a determination, and this is very important in your order somewhere, that the perpetrator has committed one of the crimes that we discussed before. So that is a key element of being able to obtain these rights. Additionally, another piece of language you need to look for in the no contact order or the protection order is the perpetrator has to be restrained from contact with you. So if it doesn't, so if you have a protective order that doesn't restrain contact, that does not, then these rights are not invoked through the statute. And also on the no contact order, it has to be the criminal no contact order. It's the ones that are through the juvenile courts, those are not counted as the protections. Once you are one of these covered individuals that obtain these rights, you do get several different rights. The first one is a protective individual, which we explained. You have to be renting an apartment or some sort of unit or dwelling that you live in. You have to be a victim of a certain crimes, and the perpetrator has to either be convicted or found to have committed those crimes. And then once again, they have to be ordered from restraining from contacting you. So once those elements are met, you have certain rights under Indiana code as a tenant. The first one is a protected individual. You may terminate the rights and obligation under a rental agreement by providing the landlord with a written notice of termination. Now, that written termination has some certain steps that you have to take to be able to terminate it. First, you must give the landlord at least 30-day written notice before the date of the termination date. So if you plan to be out on April 30th, you need to let them know 30 days, April 1st, before that date. The written notice must also have a copy of that no contact or protective order. And for certain crimes, if it's because you're a victim of domestic violence or sexual assault, you also have to provide them a copy of a safety plan. And the safety plan has some elements of itself. Once again, the plan must be dated not more than 30 days before the date on which you provide notice. The plan must be provided by an accredited domestic violence or sexual assault program. So that is encouraging you to seek help, and you have to participate in that program and get a recommendation, and the plan must recommend relocation of you as part of getting out of that lease. Now, if you do get out of that lease and it is terminated pursuant to these protections, you are not liable for expenses after the date of the termination. It's prorated to the date of the termination, and it's payable on your regular course of payment schedule. And basically, you can still be liable for other types of things if you've committed damages or something like that, but the early termination or anything rent beyond the date of the termination, you won't be liable for. And also, if you were trying to rent a new place and it was before 14 days before you intended to dwell in that unit, you're not subject to damages or penalties and getting out of that lease as a protected individual. Another interesting tidbit, if you had been sharing a place with the perpetrator and they're excluded from the dwelling unit under these leases, they will be continued to be liable with you for anything in the unit. So that's another right. Just because a perpetrator is excluded from the rental unit and he is or she is on the lease, they will remain liable. Also, when you are terminating your lease, if there's other people on it, that releases you, not other persons, and the landlord is not obligated to return any security deposits or anything until all the tenancies with all the tenants are terminated, and that would be 45 days later. So if you decide to terminate your portion, you're a co-leaser, you're moving out, the perpetrator stays, you won't be entitled to any refunds or anything like that until after 45 days. Now, as a protective person, you have a right for the landlord not to terminate your lease, refuse to renew a lease, refuse to enter a lease, or retaliate against you solely because you're a protected individual. Now, they could do all of these things for other reasons, but make sure they're not claiming other reasons, but really want to terminate a lease because you're a protected individual. That can happen. If you suspect that, once again, I recommend hiring an attorney because they cannot do that for the reason of you being a protected individual. Also, a landlord may not refuse to enter a lease because of an early termination with at another place. When you also have some rights to help protect you from the perpetrator that landlord has to participate in when you are living in a dwelling unit. The first one is upon a written request within 48 hours after you give the landlord a copy of the no contact order or order for protection, and you ask them to change their locks. They must do so and give you a new key. And I want to stop there for a second. Protective orders, it is very good to have several copies on you anyhow for your protection, and to provide a landlord a copy of it anyhow, because they could be another set of eyes for your protection if the individual is violating it. So always provide a copy either way to your landlord so that they're aware that this individual should not be contacting you or harassing you. Oops. Also, when the perpetrator is with the perpetrator is not a tenant, they have 48 hours to change the locks. But if they do live with you, they have 24 hours to change the locks so that they can't get back in and give you new keys to the lock. Now, you have to reimburse the landlord for the actual expense of changing the locks. However, if the landlord fails to change the locks within the time that they're supposed to, then you can change the locks without the landlord's permission, but you must give them a key. And if they don't do so within the time allotted, then they will have to pay for it and to reimburse you. And finally, these are statutory rights to protect victims, and they cannot be waived by the landlord, a current or former tenant. They are void. So these rights are protected by statute. Even if you have a lease agreement trying to get you to waive it, they are void and you still have these rights. Once again, I do encourage you to contact an attorney about these issues, but this presentation is to make you aware of your rights and when to contact an attorney and contact individuals for help. Does anyone have any questions? Seeing none, I will end this presentation. Thank you again for joining us today. I hope this was helpful to you, and we look forward to seeing you again in the future. Once again, if you do need services, please check us out at nclegalclinic.org. Have a great weekend, everyone. Thank you.